turn the mic. Buenas tardes, colegas.
Good afternoon, colleagues. And a good afternoon to the delegation of Croatia, to NGOs and to the general public. We're going to begin this meeting of the Human Rights Committee and examine the third periodic report of Croatia, which is going to be carried out through a list of issues prior to reporting. I'd like to welcome Ms. Sandra Kunst, head of the delegation, and the entire delegation which we have here today. They number more than 10 people, and I'm sure that we will have a very interesting dialogue with them. Without further ado then, I'd like to give the floor to the head of delegation to hear her opening statement. And other colleagues will then undoubtedly ask questions and raise queries in relation to the responses which we've received to our list of issues from the state party. So without further ado, you have the floor.
Dear Mr. Chairman, the new elected chairman of the Human Rights Commission, so I congratulate you. Honorable members of the committee, dear colleagues, ladies and gentlemen, thank you for the opportunity to present the progress the Republic of Croatia has made since the third periodic report submitted to the Human Rights Committee. Please allow me to introduce you with the members of our delegation. I'm aware that you already know their names, but I would like to represent them personally. So here we are, our colleagues from the Ministry of Social Politics and Youth, Ms. Zvijezdana Janičar, Ms. Sabina Morosini-Turčinović, and Ms. Kornelija Bojanić. From the Government Office of Gender Equality, here is Helena Štimac-Radin. From the Government Office for Human Rights and Rights of National Minority, here is Mr. Branko Sočanac. From the Ministry of Interior, Mr. Darko Žižek and Ms. Ljiljana Placeriano and Ljiljana Maglić-Radoš. From the Minister of Foreign Affairs, Ana Puljic-Žanić, and here with us is a representative of our mission here in Geneva, Ivana Kožar-Schenk. I would like to give my opening speech on English, if you allow me, and we prefer to use the interpreters during the answering and questioning in the second part. So, we all know that the International Covenant on Civil and Political Rights is the obligatory international instrument within the system of protection of human rights. The rights and freedoms established by this legal instrument are the foundation of the democratic society and supervision mechanism contributing to the protection and promotion of human rights. For these reasons, the Republic of Croatia is committed to the implementation of this international covenant and, in general, to furtherance of the human rights. One of the clear indicators of the progress in the respect that the scope of protection of human rights in Croatia has been greatly improved. One of the reasons was the process of extensive and challenging negotiation toward joining the European Union, at the end of which, on 1st of July 2013, we became a full member of the European Union. I would like to point out that Croatia, in its EU accession process, was the first country to have a fundamental rights chapter. That set of extensive and demanding criteria required to adoption of the most sophisticated standards and also a concrete track records of the faithful implementation. Dear Mr. Chairman, please allow me to address the current developments in Croatia regarding the certain segments in the field of human rights. The Republic of Croatia's efforts for continuous improvement of the legislative and institutional framework in the domain of protection and promotion of human rights are reflected in a new legislative framework, in national strategies, programs, and projects. In the period since the submission of the third periodic report in December 2013 to date, we have made progress in a significant number of areas of priority, which I would like to present to you today. With the new Free Legal Aid Act, since 1st January 2014, the access to the judicial system has been improved for the economically vulnerable categories of citizens. Primarily legal aid is now available for everyone and provided in every legal matter with no need to verify the income status. For the secondary legal aid, the Act prescribes the areas for which there is no obligatory verification of income status. Moreover, for the victims of violent crimes, there is no verification of income status at all. The protection of individuals suffering from mental disorders is a domain of special interest in terms of further improvements. A new act on the protection of persons with mental disorders has been adopted, and it's in effect since 1st January 2015, almost 3 months. Based on this act, persons with mental disorders may become parties of procedure in compliance with the Convention on Rights of Persons with Disabilities, which replaced medical approach with a human rights approach or human rights protection. Under the new provision, the attendance of the persons suffering from mental disorder at a hearing, which should be held in a psychiatric institution and only exceptionally at the court, is obligatory. In such way, the right to participate in the proceedings that may be concerned to them is guaranteed to these persons. The novelty introduced here is non-institutional psychiatric treatment for mentally incompetent persons, while the period of admission of the persons with mental disorder in the psychiatric institution has been reduced to the maximum 48 hours. The same extent of attention has been given to the raising quality of living of disabled persons. Along these lines, Croatia has adopted a new Professional Rehabilitation and Disabled Persons Employment Act, effective since 1st January 2014. The obligatory quota has been introduced for the employment of disabled persons. In order to monitor the fulfillment of this obligation, competent bodies are obliged to submit reports to the Institute for Expert Analysis, Professional Rehabilitation and Employment of Disabled Persons. New measures in the welfare system have been introduced also, and the new Welfare Act, in effect since 1st January 2014, has created a fairer, standardized and transparent system. Croatia has established a strategic implementation system oriented towards suppression of discrimination. In addition to the rights and freedoms guaranteed by the Constitution of the Republic of Croatia, there are also rights and freedoms established in the constitutional law on the rights of national minorities and in other specific laws. In September 2014, members of the task force were appointed to develop the new National Discrimination Elimination Scheme for the period from 2015-2020. A great step forward was the adoption of the Light Partnership Act in July 2014. This act enabled the conclusion of civil partnership of the same-sex couples before the national authority and entry to the register of partnership. A great progress has been achieved in the domain of gender equality, in particular with respect to the participation on the holding of political offices. In February 2015, 1 month ago, the Act on the election of the Croatian Parliament representatives was amended. Therefore, the State Election Committee will no longer accept the list of candidates if it does not include at least 40% of members of either gender. Along the same lines, the Local Election Act holds the provisions on the lists of candidates requiring the inclusion of 40% of the unrepresentative gender. Moreover, the important strategic documents are other instruments in the domain of promotion of gender equality, and reinforcement of the position of women in society have been adopted as a part of action taken under the National Gender Equality Policy for the period from 2011 till 2015. On this basis, we focused on promotion of women in business environment, increase of female participation rate on the labor market, and on ensuring balanced gender participation in the education and in the employment. Women as a special group of beneficiaries from 2040 to 2020 operating program for the efficient human resources have been introduced in a majority of investment priorities, especially with respect to the self-employment of unemployed and the fight against poverty and all forms of discrimination. In the field of the right against domestic violence, competent state administrative bodies as well as a civil society organization are continuously making efforts in the domain of prevention and protection of victims of victims of domestic violence. Croatia has become a signatory of the Convention of the Council of Europe on preventing and combating violence against women and domestic violence in January 2013. By becoming a party of this convention, Croatia has shown its permanent commitment to pursue actions focused on the promotion of gender equality, prevention of all forms of discrimination against women, and suppression of all forms of violence against women. Mr. Chairman, please allow me to mention briefly here some consequences occasion of the wartime conflicts during the 90s of the last century. The significant step forwards has been made via a new national program of psychosocial and medical aid to participants and victims of the homeland war, World War II, and returnees from the peace missions, adopted in January 2014. With respect to the mentioned programs, categories of beneficiaries has been extended to include victims and witnesses of rapes and sexual harassments during the homeland war, victims and witnesses of war crimes, disabled peacetime military veterans and members of their families too, civilian victims of the homeland war, and other categories. In order to improve the position of homeland war victims, the procedure has been initiated to adopt the Act on the Rights of Victims of Sexual Violence in the Homeland War in order to regulate the rights of victims of this form of violence and provide mechanisms for their existing of such rights. With respect to the prosecution of war crimes, Croatia has continued to investigate and prosecute perpetrators. The clear indicator of Croatia's commitment to this objective is the Memorandum of Agreement signed in September 2014 between the State Attorney Office of Republic of Croatia and the Office of the Prosecutor of the Mechanism for International Criminal Tribunals, which will continue to perform several crucial functions of the International Criminal Tribunal for Rwanda and the International Criminal Tribunal for the former Yugoslavia after the completion of their mandates. The memorandum has been signed with the scope of more efficient prosecution of perpetrators of grave violations of the international humanitarian law committed on the territory of the former Yugoslavia since 1991. In the domain of criminal justice, I would like to point out that the anticipated amendments in the criminal legislation. Since 1st January 2013, the new criminal code has become effective in Croatia and aligned with the international documents and the European Union acquis, especially in the domain of combating human trafficking and sexual exploitation of children. We have instigated the legislative procedure for the act on the amendment of the criminal code, proposing the provision of the specific criminal offense of domestic violence that would encompass the graver forms of violent behavior in the domestic environment. Closely related to the functioning of the criminal justice is the functioning of the prison system. And Croatia has strived to make improvements in this domain with respect to the treatment of prisoners. The result of these activities is a continuous reduction of the number of prisoners. Moreover, after the years of different activities in a field of law framework, in a field of probation, and of course with the different construction work, prison capacities have been increased and now we are sufficient to accommodate the existing number of prisoners in Republic of Croatia. The prisoners' health care is another domain in which substantial steps forward has been made with the new obligatory Health Care Insurance Act. Prisoners with a resistance in the Republic of Croatia are entitled to the medical insurance. In order to align the European Convention of the Prevention of Torture and Inhuman or Degrading Treatment or Punishment, in June 2014, the ordinance of disadmission and treatment of arrested and detained persons in police detention units were adopted. Thus, a higher extent of protection of human rights has been achieved for persons deprived of freedom. The Republic of Croatia has given a special attention to the prevention of human trafficking. For that proposal, parallel to the already established criminal law framework, as well as the judicial practice too, we have organized numerous media campaigns to raise the awareness. Also, a toll-free telephone SOS line was founded from the state budget and made available to all the citizens that may have some knowledge connected with human trafficking. As regards to the protection of children, we would like to mention that we have assured individual legal protection for each child in the criminal proceedings, in the conflict civil proceedings, and especially for all unaccompanied children, which guarantee the protection of children's human rights in each specific procedure. Dear Mr. Chairman, distinguished members of committee, ladies and gentlemen, in conclusion, Croatia continues to actively seek effective ways to promote civil and political human rights, tolerance, equality, and combat all forms of discrimination. In that, it has showed a readiness to embrace international standards and advice and to introduce innovative legal and institutional mechanisms for promoting and protecting human rights. With these few introductory remarks, I'm looking forward to your questions. Thank you very much.
Thank you very much, indeed. Muchas gracias.
Thank you very much for that information, which you have provided in your opening statement. With that, we will begin our dialogue. We have a number of colleagues who've already asked for the floor, And the first on my list is Mr. Rodriguez Recia, and I give him the floor now. Please go ahead.
Muy buenas tardes.
Good afternoon. Thank you very much, Chairman. I'd like to extend my welcome to this large delegation. We see that it's a delegation which has a very positive gender balance, and that's a very positive thing. We know that that leads to a very rich debate in our committee meetings such as this. I was very interested to read your report and to hear your statement. And in relation to what's already been provided in terms of information, I'd like to express my thanks for your having agreed to this new working method with the LOIPR. I think that will allow us to focus on priority matters. I think that's a very positive thing. I'd also like to thank you for the different follow-up reports which you've provided on the broadening on the report of the 17th of January 2011 and another report which was submitted later in that year, which gave us a very good overview of the way in which the government of the Republic of Croatia is making significant efforts to protect, promote and spread further respect for human rights. I'd like to focus on the first section of questions, so issues 1, 2, 3. And the easiest question, but a very important question, relates to the matters which the measures which the state has taken to broaden application of the committee's recommendations. I'm not just talking about disseminating information about the recommendations. I want to refer specifically to issue 1, which relates to the way in which promotion and dissemination of the content of the Covenant on Civil and Political Rights is carried out, because that's the text which brings us here today. With regard to that then, my question is a rather obvious one. I browsed the website of the Croatian Ministry of Justice and the website of the Foreign Ministry in Croatia. Now, I'm not particularly internet savvy, but it was rather difficult for me to find information about this. I mean, in particular, the information that I was looking for about the Covenant on Civil and Political Rights, and also about the recommendations of the committee. I didn't find the website particularly user-friendly. I didn't find information in Croatian language, and I think that's something that we could look at to assist citizens who are desirous of finding out more about their rights. It would be useful to know where this information can be found. We're not just talking about websites, of course. I'd like to know what other measures you're taking to raise awareness about the content of the Covenant on Civil and Political Rights and this committee's recommendations. Specifically concerning all the activities which you've just been talking to us about with a view to implementing human rights protection. Is there a plan? Is there a structured plan to ensure that that implementation takes place? Particularly in relation to the observations of the second report and the observations which this committee is due to make in response to the third report and this dialogue here today. I'd also like to know how civil society, have in the past and may in the future be involved in that line of work. So thinking not just about the government, but also about the possibility for social dialogue on the promotion and protection of human rights. Are there any good practices in developing this type of dialogue between the state and civil society to ensure that there can be more public debate about such protection? I'd like now to refer to issue 1, which relates to the legal and institutional developments which you've mentioned. How are international human rights treaties, and particularly the Covenant on Civil and Political Rights, applied in relation to Article 141 of the National Constitution, which gives human rights a primordial status even over domestic provisions? My question is, if in addition to that constitutional standard, that constitutional provision, you could explain how treaties are applied in the field of human rights, and particularly the Covenant on Civil and Political Rights, and whether you could give us any examples from the Constitutional Court or civil courts or any other courts where a conflict has arisen or a need to apply the Covenant on Civil and Political Rights has arisen. The provisions which are in place are all very well, but I'd like to know how in reality they are applied.
Reconociendo este esfuerzo,
we do recognise the efforts that you've made, particularly as regards ratifying a range of treaties, but we'd like to know how far other important treaties, those that have to do, for instance, with the second optional protocol on the death penalty, we would like to know progress made as regards the Convention Against Enforced Disappearances, the UN Convention on that, as well as the European Convention to Prevent and Combat Violence Against Women, as well as domestic violence. We very much welcome the fact that Croatia has joined the EU in 2013, which of course is something that is going to extend the protection of human rights regionally. And this dovetails with many of the rights set out in this covenant. But we'd like to ask you whether this ratification, the systematic ratification of treaties, this has to go hand in hand with the timely submission of reports within the UN system. I have looked at other committees, and there does seem to be a bit of a concern, particularly in the CRC, the Committee on the Rights of the Child, and the updating of that report. And there doesn't seem to be much consultation with civil society when it comes to preparing your reports. We have information that very few courts invoke these treaties, including our covenant and other more specialized covenants and treaties in this area. We don't have information. It would be useful to have information today, if not today, tomorrow, on your national human rights plan and the impact of its implementation. Do you have some sort of indicator system so that you can assess the impact of the implementation of human rights treaties? There don't seem to be clear mechanisms for supervision and taking stock of the effect and impact of such a plan and what an effect that it has on human rights, both locally, regionally, nationally. Nor do we have jurisprudence or practice on the implementation of human rights treaties as domestic law. We would also like to have you provide us with information on how far you train prosecutors, lawyers, judges in the implementation and knowledge of human rights treaties, and also as part of their knowledge of international jurisprudence pertaining to other human rights committees, and how that is automatically implemented. We're rather concerned, and this has to do with awareness raising or the lack of awareness raising here. What is the law or your law faculties doing to ensure that there is more knowledge imparted about human rights education. All this has to do with awareness raising of the Covenant and indeed specific recommendations that we have made here in order to ensure that there is greater dissemination, greater knowledge of what this committee is doing and its work. So those are my initial questions. Thank you very much, and I look forward to your answers. The Chair. Thank you, Mr. Rodriguez Recia.
Speaker on my list is Mr. Bardalashvili. Mr. Bardalashvili, you have the floor, sir.
Thank you very much, Mr. Chair. I would like to join my friend and colleague, Mr. Rodriguez Recia, and warmly welcome the distinguished delegation of the Republic of Croatia. I'll be dealing with the issues number 4, 5, 6, and 12 today. Let me start with the issue number 4, and there were some questions under this issue, and namely the questions about the implementation of the views of the committee in relation to the communications against the Republic of Croatia. First of all, let me reiterate the question about the legal procedure, or about the nature of the procedures that is available or may be available in Croatia as a follow-up to the committee's views under the optional protocol. There have been 2 cases in which committee found the state party in violation of the covenant. The state party informed the committee that in case of Paraga versus Republic of Croatia, judicial proceedings were held at different times and at different levels of the judiciary, while in Vajnović versus Croatia, the state also informed that government responded to the request of the author and actually restored his rights and provided an effective remedy to although in both cases authors stated that they are not satisfied with the remedies. However, for instance, in case of Vajnović, the committee considered that the efforts made by the state party to compensate the author were satisfactory. In the process of follow-up procedure, the state party informed the committee that it does not agree with some of the findings, but nevertheless proceeded with the implementation of the views, which is by all means an appropriate and commendable way of action. Having said that, however, I would appreciate additional information about the rules that are in place and which regulate the follow-up process. In other words, are there any formal regulations that allow the author to request the remedy from the state? With regard to the case of Paraga versus the Republic of Croatia, I acknowledge the information that author was initially awarded with 30,000 kunas, and on later stage Supreme Court additionally awarded the author with 20,000 kunas, but I would appreciate if delegation could also inform the committee whether the issue has been closed or there are any follow-up procedures that could impact the final outcome of this case. Let me now move to the next issue, which is issue number 5. In its previous concluding observations, the committee expressed concerns that some constitutional provisions limited certain rights only to the citizens of the Republic, and recommended to bring all the legislative provisions in line with the covenant. I acknowledge the response of the state party that the constitution contains general prohibition of discrimination on various grounds, and namely Article 14 provides that all persons shall be equal before the law and shall enjoy rights and freedoms regardless of their race, color, national or social origin, language, etc. However, concerns remain that Constitution also contains provisions which may indicate that in some cases constitutional protections may apply only to citizens. And while all constitutional articles are of the same value, this in practice may result in interpretation that would exclude non-nationals. For instance, Article 17 stipulates that during the state of emergency, restrictions imposed on the rights and freedoms may not result in inequality of citizens. Would that leave foreign nationals or stateless persons without formal constitutional protection? Apart from that, Article 26 of the Constitution guarantees equality before the courts for all citizens and aliens. In another version of the English translation of the Constitution, the term foreign nationals is used instead of alien. In replies, he also underlined that the Constitution guarantees equality of the rights between the citizens and foreign nationals. Therefore, I would appreciate an explanation if the term used in original text of the Constitution covers both foreign nationals as well as stateless persons residing in Croatia. With a view of the Ombudsman's report, which indicates that the statelessness in Croatia predominantly affects persons of Roma ethnicity, this provision potentially may undermine the rights of and freedoms of this vulnerable group. And finally, on the same matter, let me also kindly request from the delegation information and clarifications regarding some of the legislative provisions, such as Civil Procedural Act or State Administrative Act. As it transpired from the information provided during the previous report, there were some articles of the State Administrative System Act, and namely it was Article 80, which entitles only citizens and legal persons to submit petitions and complaints to the administrative bodies. Civil Procedure Act also contains guarantees of uniform application of the law and equality of citizens. I believe these are the articles 306 and 309. I would appreciate if the delegation could inform whether this is an accurate translation or the provisions which I've quoted are accurate, and or maybe they have been revised since the last report. There have been also reports that seem to indicate that the foreign nationals are also denied the right to free legal aid, and I would appreciate your comments on. I'm sorry, I will try to speak slower. I will appreciate your response on that regard, as well as information whether stateless persons can also apply and receive free legal aid. Let me now slowly move to the issue number 6. First of all, let me start with acknowledging positive developments. That is People's Ombudsman Office, which was established back in 1992 and has a long history, was re-evaluated by the International Coordinating Committee and accredited in 2013 with status A. The prerequisite for this evaluation, as well as its consequence, is that Ombudsman's Office will exercise broader functions already exercises and in future will exercise the broader functions. The new law expanded the mandate of the Ombudsman's Office, designated it as a national preventive mechanism against torture, and also empowered the Ombudsman to intervene in court proceedings in case of discrimination, for instance. And it has been also encouraging to learn that during the last years, the cooperation between the Ombudsman's Office and the NGOs have been improved and deepened. The cooperation has improved. However, the concerns remained regarding the funding that is necessary in order to guarantee that Ombudsman exercises new functions effectively and fulfills its role as a national preventive mechanism. Could you please specify to what extent the funding was increased for the Ombudsman institution, and whether the increase was commensurate with the extended new mandate? I would also appreciate information about the procedure which led to the development of which leads usually to the development of the budget of Ombudsman Office, how it is developed, to what extent the office itself is involved in this process. And in preparation of this for this dialogue, I came across of the recent report of the Ombudsman, which indicated that the regional offices have been opened already, and that there is a plan to open another one, I think, in the city of Split. Could you please, and which obviously improves the access to this institution. Could you please share with the committee information what is the overall goal in this regard? How many offices are intended to be opened, and what would be this time frame? And finally, on this issue, it has been also reported by that one of the main challenges which the office faces, the ombudsman faces, it's the lack of timely responses by the competent bodies to the questions submitted by the I think it rather relates to the specialized ombudsmans rather than to the national ombudsman's office. So I would be interested to learn in general what are the if there are any sanctions, for instance, if the law provides for any penalties or sanctions for those public officials or which refuse to provide information to the ombudsman, regardless of the fact whether the ombudsman whether it is a people's ombudsman or the specialized ombudsman. And now let me move to the final issue for today, and this is issue number 12, and that is concerns related to the constitutional provisions regarding proclamation of state of emergency, and namely about the compatibility of these provisions with the covenant. As it transpires from the replies to the received from the state party, there should be following preconditions for declaring state of emergency, and these are a state of war, clear and present danger to the independence and unity of the state, and a natural disaster. Article 4 of the Covenant, as well as General Comment and 29, as you may know, emphasizes on the fundamental condition which may trigger actually the proclamation of the state of emergency, and that is the situation must amount to the public emergency which threatens the life of the nation. There have been some criticisms that Article 17 of the Constitution may be interpreted in a way that would imply that it contains lower standards than that provided by the Covenant. Then danger to the unity of the state or natural disasters may be indeed real, but not necessarily life-threatening to the nation. Article 17 of the Constitution also refers to the non-derogable rights. However, as you rightly mentioned in the replies, it's not in itself sufficient. Indeed, General Comment as well as Covenant indicate that Article 4 lists, and Paragraph 2 lists the provisions of the Covenant which may not be derogated from. However, this does not mean that other articles in the Covenant may be subject to derogations at will. Derogations must be limited to the extent strictly required by the exigencies of the situation. Thus, the decision to derogate from any particular provision should be justified on case-by-case basis, and I would appreciate the views and of the delegation. To what extent you believe that the Constitution provides such guarantees? And probably I should come back to the same provision. I think it's Paragraph 2 of the Article 17, which does indicate that that extent that some derogations may take place only to the extent that is there should be adequate to the nature and the threat. However, this also links that this provision is also linked to the inequality, to the requirement of equality in relation to the citizens. Coming back to the point, to the first point which I started, to what extent do you believe that the constitutional provisions contain sufficient guarantees for every resident, for all residents of Croatia? And thank you very much in advance for the answers.
Thank you very much, Mr. Bardalashvili. And the next speaker on my list is Ms. Pasartsis. Ms. Pasartsis, you have the floor, madam.
Sorry. I would like to thank you, Mr. Chairman. I would like to add my welcome to the delegation of Croatia for the consideration of this third periodic report, for its written replies to the list of issues through the new simplified procedure. I would also like to note the information received from the Republic of Croatia on the implementation of the concluding observations of the Human Rights Committee in 2011, the two responses. My comments and questions this afternoon will address issue number 7 and issue number 9 of the list of issues prior to reporting in relation to Articles 2, Paragraph 1, 3, 7, 22, and 26 of the Covenant. I turn first to issue number 7, pertaining to discrimination and equality issues. And I would like, first of all, to take note of the positive developments in the legislative field, in particular, the adoption of the Anti-Discrimination Act in 2009 and the 2012 amendments, the Constitutional Act on the Rights of National Minorities and the 2010 amendments to this act, as well as to the strengthening of the Ombudsman Office to address a wider scope of issues of discrimination. I take note of the replies of the government and thank them. I would like to raise some outstanding questions and concerns which are reflected in some reports of UN bodies as well as in the last concluding observations of this particular body. In particular, in view of the fact that concluding observation, paragraph 5 of the concluding observation of this committee, what concrete measures have been taken by state party to combat discrimination on grounds of racial, national, or ethnic origin, as was referred there, I would like to ask the following precise questions. First of all, to what extent has the Anti-Discrimination Act been implemented in particular through case law and administrative practice? There have been raised some concerns that the number of discrimination-related court proceedings is low, while recording of cases is not, to this point, very systematic and comprehensive. I would like a comment on the reason for this situation, whether it is due to lack of public dissemination knowledge to the public, how the Anti-Discrimination Act is diffused to the public, whether there are any fears of victimization, and so forth. My second precise question is, what are the percentage of rulings in favor or against actions pertaining to discriminations? Have there been collective complaints filed, in particular with regard to discrimination on the basis of race, ethnic origin, affiliation, color, or religion? What have been the sanctions awarded in such cases where the action was upheld? Furthermore, I would like to ask what concrete measures have been taken to protect members of the Serb minority against discrimination, as was raised in this committee's concluding observation, paragraph 5. There are some reports that Croatian Serbs continue to face some problems as regards the return, some problems regards housing and public sector employment. Have there been any measures taken to address these outstanding issues, in particular restitution of tenancy rights to social housing vacated during the 1991-1995 conflict? Furthermore, what specific measures have been taken to address violence, harassment, and discrimination of Roma, concerns which have been raised specifically in the report of the Council of Europe's Commissioner in April 2010. There has been a judgment of the European Court of Human Rights, the Orsus versus others versus Croatia, in 2010. 4 years have elapsed. What measures have been taken? How many Roma children still attend segregated classes? And is the Free Legal Aid Act, has it been brought to the awareness of the Roma population? One further question is, in particular, as a follow-up to the concluding observations, what measures have been taken concerning the official and public use of languages of national minorities, education in minority languages and preservation of religion and establishment of religious communities. It would appear that there has been a recent judgment, 2010 again, on the Union of Churches versus Croatia. I would like a comment by the delegation, in particular in regards to the prohibition of discrimination and the execution implementation of this judgment in Croatia. I understand it is the first to really address issues of religion regarding Croatia, so I would like to have a comment on this. Furthermore, regarding national preservation of languages and eventual discrimination, there appears to be reports that there were some aggravated, some probably not generalized, but incidents, an initiative calling for a referendum to raise the threshold for the exercising the right to equal official use of language and script. To my knowledge, in July 2014, the Constitutional Court did rule this petition of a referendum unconstitutional. So for the moment, I understand that the current law on minority setting out the threshold at 1/3 of the population is standing. I would like a comment on this by the delegation. I would like now to turn to the second issue in this large question. My others will be shorter, Chairperson. To hate crimes in particular, because this also was raised in the concluding observations. I would like some information on the number of hate crimes, or whether there has been a recording of hate crimes. It appears to be that there has been little case law to this date. Reports do say that there have been instances, again, probably sporadic, but instances of hate speeches, whether it is within sports, soccer games, some speeches of public figures, or information disseminated on the internet. I do understand that the hate crime provisions were modified in 2013. I do understand that there are harsher penalties for hate crime, which is now a qualified form of crime. I understand also that there is a hate crimes protocol that has been established. What are the practical effects of these measures? Are there any, and what are the practical effects? Do Croatian authorities ensure a prompt and thorough investigation and prosecution of perpetrators? And is there a way of tracking data and collecting proceedings in this sphere? I might come back on that following the delegation's replies. I would like a comment as well on the duty the police has to identify motives behind hate crimes, and the duty the police has to the classification of hate crimes. So I would like some information on that. I will turn now to issue number 9 and be very brief, Mr. Chairperson. I see you are looking at me. I will be very brief. I do thank the delegation, the head of delegation, for her information concerning the strategy on the opportunities for disabled persons. Her opening statement was quite lengthy in this, which makes my task less in this field. Of all the legislation that has been passed, put into place for to reduce any sort of abuses of involuntary placement. I take note of this new legislation. My question would be here whether how this new legislation will be implemented in regards to disabled persons or persons with disabilities that are already under guardianship or are already institutionalized. will they have the opportunity to avail themselves of the new remedies put in place? These will be my questions for now. Thank you, Mr. Chairperson. Thank you.
Thank you very much, Señora Pasartzis.
Thank you, Madam Pasazes. I look at you with exactly the same degree of affection and respect as other colleagues, so you absolutely don't have to apologize, Madam.
My list is Ms. Waterwell. Ms. Waterwell, you have the floor, Madam.
Thank you, Mr. President. Let me also join my colleagues in warmly welcoming this distinguished delegation of the Republic of Croatia. I'm going to ask questions on issue number 8, 10, and 11. We know the detailed information and some statistical data which you have provided us on this issue. But going back to paragraph 76 of the list of issues prior to reporting, you have stated that in 2012, the government adopted the rules of procedure in case of sexual violence with the aim of ensuring immediate, compassionate, gender-sensitive, and culturally sensitive comprehensive help and support of all competent authorities. My question is, can you elaborate more on this issue and tell us what the help and support consists of? What is the impact of this new strategy compared to previous years? In paragraph 77, you also stated that the action plan for improving the position of women in rural areas is currently being drafted. Have you completed the draft? And have you already started the implementation of it? Can you measure the impact of these workshops, because you have also organized a lot of workshops and programs? Can you measure the impact of these workshops and programs and plans, what they have on the improvement of the position of women in the rural areas? Can you share the data with the committee which you have gathered on these women? Because you tell us you have some data and we haven't received this data. We also know the progress you have made in the participation of women in public affairs. What was the result of the evaluation of the implementation of the gender equality education, which you have also described, as presented in civic education curriculum in elementary and high schools? Turning to issue number 10, we thank you, and that's against violence against women, and we thank you for the data on the shelters for victims of domestic violence. You mentioned that there are shelters run by civil society and religious organizations, among others. But I miss shelters run by the state. Are there no state-run shelters? And if so, how many are there? You have provided us with the number of beneficiaries and the financial support. My question is the financial support adequate to run the shelter? And if not, what are the measures you will take to adequately support these shelters? You have not submitted statistical data covering the period under review on the number of complaints filed concerning different forms of violence against women and the number of convictions handed down, including the sentences imposed and the compensation awarded to the victims. If you don't have the data at hand, you may send it in writing. The chair will provide you with the information on the 48 rules on submission. We also have information that Croatia provides only 267 shelter spaces in a total of 10 state contracted safe houses and 7 autonomous shelters, short of the Council of Europe's recommendation of 428 spaces. We also have information that the ministry has offered per bed funding, which does not reflect the reality of shelters' costs and has advised shelters to seek funding elsewhere. Will you comment on these reports? And also that funding is often delayed for months, which disrupts continuous operation and services for victims. Turning to issue number 11, that's on domestic violence. First, I note with satisfaction that there is a compulsory psychosocial treatment for the perpetrators of domestic violence besides the other protective measures. Is this measure monitored, and by whom? In paragraph 116, you submit that the court must warn the proponent about the consequences of the failure to submit an indictment proposal because that will result in the repeal of the decision on protective measure application. My question is, are the victims aware of this measure? How are they informed, and who informed them? Paragraph 117, you describe the appeals procedure. Are persons who appeal represented by counsel, and is this compulsory? Because I think that this procedure requires some knowledge, and if you don't have the legal knowledge, I think that they won't understand this procedure. In paragraph 123, you stated in the third sentence, in situation where it is undoubtedly clear that the person is primarily a victim, when beyond the scope of self-defense and enter the sphere of violence, the police report both participants. My question is, are people aware of this? And who determined when one went beyond the scope of self-defense? And I have some reports. And the reports say that dual arrests in Croatia are common. In general, research shows men are the perpetrators of domestic violence in 95% of the time. But police arrest and charge women in 43.2% of domestic violence cases, and that dual arrest and convictions occur for a number of reasons. And I have an example where a woman whose husband had threatened to kill her 6 times reported each time to the police, and the police did nothing. The 7th time, she told the police that he was threatening to kill her again, and he said to the police that she had said to him, "You are a senile fool." The reaction of the police to her was, "Ma'am, you really insulted him." The police wrote an indictment proposing that he pay a fine of 1,000 kuna and she pay a fine of 6,000 kuna. Can you report on this? We have another example that the women who have never lived with the perpetrator and have no children with him are not entitled to any protection under the law on protection from domestic violence. Croatian domestic violence law classifies economic and psychological violence on par with physical violence. Thus, police equate name-calling, insults, and even quarreling with physical harm. The law on protection against domestic violence requires a victim seeking an emergency protective order to show her life is in danger, a very high requirement. And judges have refused to issue emergency protective orders for non-specific threats or other violent acts that do not meet this bar. We also have information that judges are not always available to consider urgent requests for protection within 24 hours as required, and that a betterer can postpone enforcement of protective orders by filing an appeal, leaving his victim vulnerable to further abuse and without any recourse. And my last comment is that the criminal code does not include probation on harassment and stalking. And with that, Madam, I thank you in advance for your replies. Thank you, Mr. Chair.
Thank you very much, Ms. Waterval. Quiero
I'd like to recall that we are now holding a dialogue about issues 1 to 12, which is the first part of our discussion. Issues 1 to 12. I have one further speaker on my list, and that is Mr. Muhumuza. You have the floor.
Thank you very much, Chair, and I'd like to join others before me in recognizing and congratulating the Croatian delegation upon their elaborate presentation. No doubt Croatia has played an important and significant part as far as ratification of international instruments is concerned. One of the latest, I should say, is the Arms Trade Treaty. Article 7 of the ATT requires that a state party should ensure that the arms produced should not be exported, and I'm paraphrasing, to places where they would be used in terrorist activities. At the domestic level, your own laws prohibit the export of arms if they are going to be used in terrorist activities. I have information whereby no less a state official than the president of Croatia said that unfortunately, they have no control over the arms, over state parties where these arms might end if, as long as they are not in Croatia, as how those arms might be used. As a state party of the ATT, and as a country which has on its domestic legislation laws that prohibit such occurrences, how concerned are you that Croatian-made firearms have found their way into the hands of terrorists, particularly the Islamic State in Iraq and Syria, ISIS? I thank you.
Thank you very much, Mr. Muhumuza. Como ve, señora jefa de la...
As you can see, head of delegation, we have a very inquisitive committee. They ask many questions, but we will save enough time for you to be able to prepare your responses. So we'll now give you around 20 minutes so that you can, together with your delegation, organise your responses to this first round of questions. We'll then have the potential for some follow-up questions to pursue our debate further. And as Ms. Watervall, my colleague, was saying earlier, sometimes we ask for information which is too detailed to be able to be supplied here. But before the end of the process, you'll have 48 further hours so that you can submit any detailed responses in writing. So we're going to have a rest now, and you are going to work very hard for 20 minutes to prepare your responses to this first round of questions. We therefore adjourn until 25 to 5. Thank you.
Muy bien, colegas. Retomamos.
Let's resume our work this afternoon, ladies and gentlemen, colleagues. We will be now hearing the answers from the delegation to the questions addressed to them. So I'd like to hand over now to Her Excellency Sandra Kunst, Head of Delegation, to start the answers. Thank you. You have the floor, madam.
Hvala vam lijepo. Dozvolite mi.
Thank you very much. Allow me to, during the time you gave us for preparation, we have managed to set up a plan. Considering the scope of the questions, we would like to begin with the basic topic to encompass the whole system. We would like to begin with institutional and legislative framework for human rights in the Republic of Croatia. In this regard, I would like to give the floor to Mr. Branko Socanec, who is the head of the Office for Human Rights and Rights of National Minorities. Mr. Socanec, you have the floor.
Members of delegation. I would like also to welcome and hail all the members of Human Rights Committee, and we believe that we will try to answer to a number of questions that you posed just earlier today. Dakle,
so, human rights are a constitutional category in the Republic of Croatia, and they are visible from a number of laws and subordinate laws that derive from the Constitution of the Republic of Croatia. Human rights are also rank high in the government agenda, the government of the Republic of Croatia. And just like our delegation had outlined in the introductory speech, she said that Croatia, in the pre-accession discussion, we underwent a detailed screening that no country before us had gone through, with 35 chapters. During the negotiations for the accession to the European Union, the government of the Republic of Croatia, or the Croatian Parliament, adopted hundreds of laws, literally hundreds of laws, to align with acquis communautaire. And I need to note that, considering the number of laws adopted, we in the state administration are still not really, since we have joined the European Union, and we've been member for 2 years, so we are still not very good at the procedures. In 2012, the Office for Human Rights and the Rights of National Minorities was established as a professional service, conducting professional activities of determining and realizing policies for protection and promotion of human rights and rights of minorities. This office continued to conduct affairs that used to be the activities of independent offices before. Within the framework, within the scope of this office, is assessing the human rights situation and the situation of rights of national minorities, and alignment of national legislation with the provisions of the Constitutional Act on National Minorities, and with numerous international instruments relating to human rights and many other areas. And I would like to single out human trafficking, hate crimes, and others. I would like to point out that the cooperation of the office with the competent ministries and other state administration bodies and other institutions, such as the Council for National Minorities, Ombudsman, so not just the general ombudsman, but the specialized ombudsman, 3 others, representatives of local society and representatives of international institutions and NGOs, non-governmental organizations. The Office for Human Rights is the point of contact of various international organizations, Council of Europe, other bodies, European Commission, Organization for European Security and Cooperation, and other UN bodies. From the scope of the office, it is visible that it targets the encompassing promotion and development of human rights and rights of human minorities, and we believe that the office is well staffed and funded. I would like to point out that even before the government issued the decision on merging 2 previous bodies into the office, the idea for merging the bodies into the office originated from the non-governmental organizations. Soon afterwards, after the offices were merged, a national program was established, program for promotion of human rights from 2013 to 2016 that the government of Croatia adopted in April 2013. In the same year, in July, the government adopted the action plan for removal of obstacles of realization of particular rights in integration of aliens for the period 2013 to 2015. The office monitors the implementation and coordinates the activities of the Standing Committee for the Integration of Aliens in the Society in the Republic of Croatia. Also, the office coordinates and monitors the implementation of recommendations that is provided by the Ombudsman and reports on those activities. Furthermore, the office is a central body for collecting and publishing data on hate crimes, and collects and consolidates statistical data on semi-annual and annual basis. The office is also coordinator in the area of human trafficking and acts as a secretariat for International Committee for Combating Human Trafficking. The office also monitors the implementation of the Constitutional Act on the rights of minorities, national minorities, and the action plan for the implementation of the said Constitutional Act, and also coordinates the draft of the said legislative act. As for the rights of the Roma national minority, the office monitors the implementation of the national strategy for the inclusion of the Roma and relevant action plan, and coordinates the activities of National Commission for the monitoring of implementation of the national strategy for the Roma, headed by the Vice President of the government. The office also supports technical support to the working group for hate crimes, to the National Committee of the against human trafficking, and supports the national strategy for the Roma. I would like to point out that in all the mentioned bodies, apart from the state administration members, the members of civil organizations are also participating, and they are equal participants and are able to co-create and co-decide. I would like to use this opportunity to commend the work of numerous non-governmental organizations included in the set processes. The Commission for Human Rights was established by the decision of the head of the Office for Rights in 2012 for human rights and rights of national minorities. His task is to monitor the implementation of the regulations, plans, strategies relating to human rights, especially National Program of the Protection and Promotion of Human Rights, makes proposals on the amendments and adoption of relevant legislation, provides guidelines for establishing strategies in the said area, collects data on the situation or with the human rights, and based on the data proposes measures how to deal with the issues that were observed, monitors the implementation of international treaties on human rights that Croatia is a state party of, and considers reports and complaints that were addressed to the Croatia by the international organizations, and compares them with the real situation and proposes adequate measures if there is a need to do so. Furthermore, it cooperates with organizations of civil society organization, the Office of the Ombudsman and Special Ombudsman, and other independent organizations. Committees of the Croatian Parliament that deal with protection of human rights and rights of national minorities, scientific institutions, county coordination bodies for human rights, educational institutions. It proposes the establishment, the organization of professional seminars and workshops on international and national level, organizes sessions on the challenges, latest challenges in the area of human rights, and proposes the establishment of ad hoc working groups and bodies to cover particular subjects of national importance, or dealing with particular issues in the area of human rights and rights of minorities. The members of the Commission, besides state administration members, include the members from educational institutions and civil society. As for the work, I would like to say that the Commission, since its establishment, has held 7 sessions with the following topics: free legal aid, introduction of civic education curriculum, human rights of civilians, lesbian and gay and transgender rights, implementation of national program for the protection and promotion of human rights, and a week ago there was a last session. Transgender rights was the topic on the agenda for this session. Also, in cooperation with the Agency for Basic Rights, Fundamental Rights, International Agency, there was a workshop for the members of the Commission on improving and increasing the capacities, building the capacities. I would like to note that apart from civil society organization participation, unfortunately, out of 7 sessions, only in 3 sessions there were non-governmental organization members present. In accordance with the decision on the human rights and rights of national minorities, the office is monitoring the reports of the National Ombudsman, the report on the activities, the report on the occurrence of discrimination, and the report on the National Preventive Mechanism for Prevention of Torture and other cruel and inhumane behavior and punishments. In accordance with the above said, the Office of the Ombudsman delivers the recommendations following from the report and requires the statement and all the future activities that follow the recommendations. Based on the collected data, the office
trenutačno je u fazi priprema izvješća za 2013. godinu. Budući da je jedno od pitanja bilo i uključenost nevladinih udruga u cijeli institut.
So one of the questions was also, I think I have informed by this to which extent non-governmental organizations have been included in the entire process. So they have equal rights to propose, and of course they are members of all working groups. Also, one of the questions was a delay of the answers of the ministry when we're talking about the reports of the ombudswoman. Indeed, there is a certain delay, but this is a matter of a procedure because the ombudswoman's report has to pass the parliamentary procedure, and after it has been adopted by the parliament, it goes via our office to the ministries in charge who have to give their statements. We coordinate this all and we prepare a joint report. According to the law, we have to resend this joint report to the ministries in charge, and of course the process lasts. So in I cooperate with our ombudswoman, and I must say that we also bilaterally are thinking of different options in order to speed up the entire procedure. Thank you. This will be all on my part. Later on, I can add more. Thank you. After the general introductory part, from which it is obvious that we have made the system not only of the implementation of the norms, which have the objective of protection of human rights, but also the system of the implementation of those norms. I would like to take a look at 3 questions which have been asked here and which have to do with the publishing of the text of the covenant in the Croatian language with the aim of raising the awareness of the public of the content of the covenant. The covenant was published on the website of the Ministry of Justice in October 2013, so that was 2 years ago. It is a fact that at a certain point of time we have been reconstructing our website because the Croatian government believed that all the information which have to do with the government and with the ministry have to have an equal design for the citizens to be able to find the information more easily. And at the moment of this redesign, the covenant was not on the website, or the information was not available all the time, so there was probably this period which is not the case anymore. The website has been updated and the covenant is now on the website of the Ministry of Justice of the Republic of Croatia's government. It is accessible to all citizens. Other 2 questions have been asked regarding 2 cases which were going on at Croatian courts. I must say that we are aware of the fact that in order to illustrate a certain procedure, the cases are going to be pointed out to which might not reflect the real status or jurisprudence of the legal system. The 2 cases have been finalized and they have been put ad acta. In the Vojnović case, it has been sent to the Human Rights Committee regarding the rights to apartment. I must say that a heritage of our former socialist system was the tenancy rights. We used to call it tenancy rights. And it is different from property. It is not possession. So the bearer, the party in the case asked for the protection of their tenancy rights, and it was and the case ended in an out-of-court settlement, and it was even something that was praised. The Republic of Croatia was praised for having solved this case in a good way. The other is the Paraga versus Croatia case. It is a citizen who filed a claim against the Republic of Croatia for having been unlawfully arrested. And this was a case from 21. It was solved in the first instance in 23, and in 26 there was a
appeal.
There was an appeal, and at that time the claimant had also the right to file the case to the Supreme Court. So on the basis of the revisions filed by the claimer, the Supreme Court has raised the amount of this reward, probably also regarding the time which passed. It was 7 years after the event had happened. So after having answered those questions, I propose that we return to the general question, and that is the protection from discrimination. So I would like to ask Mr. Sochanets once more to give his statement. So, as it has already been said, the Act on Discrimination, Anti-Discrimination Act was put in force on the 1st of January 29, and it is a foundation for numerous activities to follow. By this act, the Ombudsman was nominated to be the central body for anti-discrimination, and the act also introduced the institution of an interferer on the side of the victim, as well as the possibility of collective claims for discrimination, thus protecting the protection of the citizens. The Act protects witnesses of discrimination and defines a broad scope of persons who have to claim and report, with the aim of strengthening the institution of the Ombudsman. His jurisdiction is expanded to legal and private persons, strengthens the coordination with other ombudsmen as well as of courts, and it enables the state authority bodies to give recommendations, and at a certain point of time the Human Rights Center has also been added to this. We have 4 ombudsmen, or it would be better to say ombudswomen, because we have a complete gender balance. Now it is only a matter of the other side, because we lack ombudsmen. With the aim of strengthening the implementation of the Anti-Discriminatory Act, the Human Rights and National Minorities Rights Office organized education for judges, solicitors, state officers, the media, employers, unions, on the issues of the acquis communautaire and anti-discrimination, as well as the Act itself. Furthermore, the office conducted numerous national campaigns with the aim of raising the awareness on the non-acceptability of discriminatory treatment and proceedings. The National Plan for Combating Discrimination for 2008 to 2013 was adopted in 2008, and by this document the status was identified, aims were set, and measures planned for implementing them in order to upgrade the existing system of the protection of discrimination. The national plan had the following objectives: expanding the existing national documents in line with the conclusions of the International Conference Against Racism, racial discrimination, xenophobia, and similar forms of non-tolerance. Furthermore, recommendations of the UN Committee for removing racial discrimination and recommendations of the European Commission against racism and intolerance, the ACRI. At the same time, the system of measures for removing discrimination is being amended in line with European documents and assessment of the status as part of the process of the accession of Croatia to the European Union. And I must say that the hardest chapter in the integration process was this for us now, for the state administration of the Republic of Croatia, a famous chapter 23, justice and human rights, with numerous benchmarks. Furthermore, we can also speak about strengthening the public awareness of the right to non-discrimination, reaching the corresponding representation of discriminated social groups at all levels of governance, strengthening their participation in the public sphere and public life, accepting differences, education of public officers and justice officers and servants on the meaning of all forms of discrimination, promoting non-discrimination of citizens, achieving a larger degree of tolerance in the society, etc. So it is important to point out that last year the Office for Human Rights and National Minority Rights has established a working group which has the aim of designing and drafting a new national plan for 2015 to 2020. And within this process, an internal evaluation is also taking place of implementing the measures of the national plan for combating discrimination for 2008 till 2013. I would like to point out that the government of the Republic of Croatia in 2013 adopted the national plan for respecting and promoting human rights in 2013-2016 period, and as priority areas the combating of racial discrimination and national minorities discrimination has been set. The project is called Drafting a New National Plan for Combating Discrimination for the period 2015 to 2020. The project is being implemented within the framework of the program of the European Union, the Community for Employment and Social Solidarity, so-called Progress. As the title of the project says, the objective of the project is drafting a new national plan through promoting the exchange of information and knowledge among all key stakeholders, such as the bodies of state authority, state administration, the bodies of local self-administration, justice and other agencies, in order for the entire issue of anti-discrimination to make it closer to the policy at the national level, but also the European Union level, Croatia being its full member. The new national plan is going to be confronted with the challenges with which the national bodies were confronted during the implementation of now Act on Anti-Discriminatory Act, thus covering significant broad areas from life, which are defined by law, such as employment, working conditions, education, public informing, the media, access to goods and services, and providing them, organizations of civil society, political parties, or any other organizations, as well as participating in cultural and artistic activities. In line with the Anti-Discriminatory Act, this plan is going to cover numerous topics from numerous directives, EU directives, on the basis of race, religion, age, sexual orientation, disability. The project is based on building partnership between different stakeholders, state authorities, NGOs, justice, and the regional and local authorities.
The main task of the task group is the proposal for the action plan. The project has carried out, the implementation of the project has carried out, and is going to end on September 1st this year. So far, the task force has met 2 times at workshops, following the previous analysis of the conditions in the strategic areas covering by the national plan. The measures have been elaborated, and the third final workshop will cover the indicators to cover the implementation of the measures in the future. After the draft of the national plan, the office plans to organize regional public advisory sessions and roundtables. And we will make the forms and questionnaires in order to effectively implement the same. And finally, within this project, in December last year, we had the conference commemorating 5 years of the Anti-Discrimination Act. So far, that's it for now. If you allow me, we would like to continue with a special area where we faced challenges of prevention of discrimination. That is result of our unique experience when we consider the EU member states and the very few experiences with such experiences in the world. As you know, Croatia had a war in the 1990s, and of course the consequences of such events are reflected in displacement of persons that used to live in the region, and in the way how to allow this person not to be discriminated. The questions you have posed cover the topic of housing care for displaced persons, and this is a topic that has our full attention in all governments after the war, even during the war. So we have special office for reconstruction and housing care, and we have several areas that this office targets to meet the requirements in a satisfactory way. And I will give the floor to Mrs. Ana Puljic, but let me just outline the basics. We have established the ownership of the property, but the other persons have been using it, so now it's the question who gets the property. And of course the special property categories of the former legal system, and the ways how to balance the rights without discriminating anybody, and this is an area of particular interest to us. I will allow Mrs. Ana to continue with this topic.
About the implementation of the activities related to the return of internally displaced persons, returnees and refugees, and about our national program of return, reconstruction and housing program. I will now continue in Croatian because we deciding among our members of delegation to give answers in Croatian.
During the war in the Republic of Croatia, around 550,000 persons have left their residence and had temporary accommodation in other areas of Croatia that were not directly threatened by the war. At the same time, Croatia has accepted 400,000 refugees from Bosnia and Herzegovina. At the same time, 250,000 people left Croatia. Since the onset of the activities concerning the returnees and refugees in Croatia, we have records of 354,000 returnees, 21,000 are former displaced persons, and 130,000 minority returnees. So far, Croatia has expended €5.5 billion for national programs for returnees, for displaced persons and refugees, for housing care. We have to say that 5% was awarded by international donation, and everything else was expended from the Croatian budget. Croatia has, through the reconstruction project, constructed, built, and renovated 150,000 housing units worth 16.8 billion kuna, which is about 2.2 billion euros. Croatia has also, through housing care program, in accordance with the relevant legislation, for the former tenancy right holders, provided housing care for 35,000 families. Since the onset of the program, and that was in 2001, there was almost 18,000 requests for the housing care. Through administration procedures, 13,300 were resolved. 9,500 requests were positively resolved. For 8,360 requests, housing units were provided. 4,434 remaining requests are still in process of examination. Within housing care program for refugees and returnees, Croatia has returned to the owners almost 19,280 houses. This is the topic of so-called unauthorized investments. So the settlements have been made in an effective and reasonable way. 34 units remain to be returned to the owners. 16 cases relate to private property and 18 to unauthorized investment. The funds expended for the returnees, housing care for the returnees in 2014 amounts to 300 million kuna, which is 40 million euros. Returnees and refugees who would like to return to their place of residence in accordance with the relevant law have the right to the status of the returnee, which entitles them to the healthcare and monetary compensation in the duration of 6 months. As far as the other activities concerning returnees and displaced persons, Croatia has conducted activities within regional housing care program in cooperation with Bosnia and Herzegovina and Serbia. The same program, within the same program, the returnees can make decision in terms of integration of the current place of residence, country of residence, or in terms of return to their previous residence or country of residence. Through regional housing care program, Croatia plans to provide housing care for 3,541 family, or 8,529 persons. And for that purpose, we have budgeted the necessary funds in the amount of 119.7 million euros. Out of the mentioned number of family, 2,900 relate to the former tenancy right holders. The budgeted contribution of Croatia in the said program is 25%, or 29.9 million euro. At this moment, Croatia has funds from donation in the amount of 10.9 million euro that will be expended and that have been approved for the following projects: construction of a residential complex in Korenica, that for 29 families, former tenancy right holders. The agreement on the ground was signed in 2014, and the construction should be done by June 2015. The construction of residential complex in Knin with 40 housing units. This project will allow housing for 40 families that are former tenancy right holders. And to a lesser extent, the users for the home in Strmica. The agreement on the ground has been signed already. Actually, it was signed last year, and the construction is planned for spring this year. Reconstruction of the nursing home in Glina, where 75 persons from the organized accommodation will be accommodated. The agreement has been signed as well, and the construction is also planned for spring this year. The purchase of 101 apartments for the former tenancy right holders in the areas of special state concern. The agreement on the grant was signed in June 2014. And the purchase realization has already begun with 44 housing units in 2014. In the first half of 2015, the purchase of remaining apartments is expected. I would like to point out that this project has realized the first housing care finalized solution for the former tenancy right holders. And the project in Benkovac, residential complex in Benkovac, that was approved in December 2014 for the housing care, providing housing care of 21 families, former tenancy right holders, and persons who had refugee status. During 2015, the State Office for Housing Care has a plan to apply for the CEB projects, for the funds of the CEB, and has several other projects in plan. We are aware that we are expected to be more expedient with the cases. Croatia has fully, through its legislation framework, established the resolution of the cases for former tenancy right holders in line with the law that regulates the areas of special state concern, in line with the decree on the status of the former tenancy right holders and members of their families, and the conditions and the procedure for their housing care, and in line with the Reconstruction Act. Also, after providing housing units and return of the persons to the Republic of Croatia, the persons can make an application and realize their rights in the status of displaced persons and refugees. I would like to point out that the key problem for return is the time passed, the time that has passed between their leave from Croatia, their exit, and today, and the present day. And this was the time that the conditions have changed significantly. In order to resolve the remaining cases as effectively and as expediently, the competence was also transferred to the county offices. The Republic of Croatia invests maximum efforts to ensure the return and integration of refugees, returnees, displaced persons through national programs, through National Housing Care Program and the Regional Housing Care Program. Still, the return is not just about providing housing units, but meeting other preconditions to make the individual, every individual, on a personal level, for such an individual to make the decision when to return to Croatia. And here I mean the employment in another country or local integration in the recipient country. In this regard, I would like to point out that Croatia intensively cooperates with other regional countries and within the cooperation of UNHCR and the CEB, and that we commend the UNHCR recommendation on determination of refugee status for the persons from the Republic of Croatia, along with the recommendation of the implementation of Sarajevo process, for which we hold that provides good, solid background and guidelines for permanent solutions of the questions of refugees.
We are satisfied with the information that the number of refugees in the region is being decreased, which also confirms that the recommendation on stopping the refugee status for persons from the Republic of Croatia contributes to solving the refugee situation.
Dear members of the committee, this is all from my side.
Hvala, Ana. Nadamo se.
Thank you, Anna. We hope that out of the numerous facts, you were able to gain a picture of the complexity of the problems with which the Republic of Croatia was confronted in solving the consequences of the war. And this is not only in terms of financing, but also in the need of having to close the legal framework and of creating the institutions to follow this legal framework. Part of the question which were asked here had to do also with hate crimes and the position of the Roma community in the Republic of Croatia. So I propose that Mr. Socianac gives the answer to those questions. I would like to start from the Roma issue, as this is a broader issue. For start, we have to know that in the Republic of Croatia, 22 national minorities have been identified, which is a curiosity, I should say, in the entire European area, because in the entire European area there is not such a number of national minorities to be identified and recognized by the Constitution. One of them is also the Roma national minority. Excuse me, Branko, if I may. If we could only give maybe a more concise answer, because as Mr. Chairperson has said, we would like to leave the last 10 minutes for a few follow-up questions. So the question was education of Roma and the case Oršuš versus Croatia. Last year, from the state budget, a total of 9,440,000 kuna was allocated, which is about 1.3 billion euro, in order to implement the measures of education for national minorities. Numerous measures are already being implemented as a follow-up to this recommendation, and this was all consequence of this verdict in the Oršuš case. So a year before having to start primary education, 5 hours per day, or preparation measures are being taken for integration in the primary school system. And this preschool is also part of the national strategy for Roma and an action plan for the implementation of the national strategy of the integration of Roma for the period of 2013 to 2016. So I would like to point out that the national strategy was adopted according to the framework of the European Union for the integration of Roma 2013 to 2020, and the minimal objective is by 2020 for all Roma children to finish primary school. Of course, this is a very ambitious objective, and we will see how the member states, including the Republic of Croatia, are going to meet this objective. The total number of Roma children included in the preschool programs is 873. In the Međimurje county, and this is a county in the Republic of Croatia, which is in the northwestern part of Croatia with the largest number of Roma, and about 2/3 of Roma are estimated to live in this county. In this county, about 300 children are included in the preschool program. Furthermore, since related to the previous school year, we have noted the increased number of children in the preschool and schooling program. In the 2013 to 2014 school year, we had 769 children, out of which 390 in the preschool program. That is in the and from the state budget for preschool education and free school, which also includes the share of the parents, 2,816,000, or slightly less than 3 kuna, or slightly less than 300,000 euro has been spent. In the program of learning Croatian language, the Ministry of Education, Science and Sports, according to their data, the total number of children who in the school year 2014 to 2015 were inscribed in the first grade of primary school is 41,012, out of which 1,197 in the Međimurje county. The data on the number of children in the first class who had special Croatian classes. Unfortunately, we do not have this information, but the Roma population, the total number of pupils who are members of the Roma national minorities in the primary schools in Croatia, the total number is 443 who had special Croatian classes. And in Međimurje county, 162. Children from the Roma national minority who have been included in the daily care program in schools. The number is 343, out of which 82 from the Međimurje county. The strategy for the inclusion of Roma in the strategy 2013 to 2020, with the accompanying action plan, the daily care for members of the Roma national minorities being financed from the state budget by the Ministry of Education and Sports, for all those who have applied for this, for extended stay at schools. And there is a need to increase the financing as well as to find new financing sources. For the next period, ensuring funds from the European Social Fund is foreseen, with special accent on the activities which include the Roma population, and this includes also including the Roma children in the formal educational system at all levels, and with special accent on preschool activities and extended stay. Measures against parents who neglect educational needs of the Roma children, according to the statement of the social care center from Čakovec. I propose that the colleague continues. I will try to be very brief because of the time. So I would only like to say something about the activities conducted by the Social Care Center Čakovec in the Međimurje County and the Family Center there. So there are very many activities which were conducted with parents and with children, in the sense of going to school and taking over the responsibilities of parenthood, combating bad forms of behavior, bad behavior. So if we would calculate all and consider all the workshops, we can say that we have positive results, because there was a higher degree of attendance of school among children, better cooperation of parents with schools, which is not always the case with the Roma. They were included in monitoring the progress and the parents, and in monitoring their progress of their children. It has been noted that there was the need to help them with giving them money for school lunch, and the number of beggars has decreased in the Varaždin and Čakovec regions. If we take a look at problems there used to be and complaints about Roma not attending schools, there is less such problems. So in 2020 we had 65 cases, in 2013 39, and 2014 17 cases, which is a good indicator. Talking about the protection of children, the centers would decide on different measures in neglecting children and not taking care of them, so that they were warned. 22 parents were warned in 2012. In 2013 there was 19 warnings, and in 2014 11 warnings to parents because of non-attendance of their children. And I can also say that we have a larger number of Roma children finishing primary education and even secondary education. We have the information that there is less dropout rate has decreased of the Roma children from school. So we can take a look at all the measures which have been taken by the schools and the social care centers. Thank you.
Considering the being short of time, let's see.
Thank you very much.
Tenemos unos minutos.
We have a few more minutes just for follow-up questions.
Imamo nekoliko minuta za follow-up question.
I'm pretty sure that some colleagues would like to ask follow-up questions, so I'd ask you to make them very specific questions. The first speaker on my list, Mr. Ruiz Recia.
Muchas gracias, señor presidente, y
Thank you, Chairman, and I'd particularly like to thank the delegation. The delegation has made a huge effort to answer so many questions. They've given us an awful lot of statistics and information. In fact, it's rather difficult to process all that information. But of course, we are responsible for that. This is a very intense procedure, and we've had a barrage of data and information coming in. I'd like to go back, if I may, to the issue of actually assessing the impact, quantifying the impact of all these programs and norms. From what I've understood and from what I've read, of course, there is a clear framework, structures, and really impressive programs and plans when it comes to human rights. But I would like to know, perhaps you give us something that is more tangible, not only in terms of statistics, but indicators of the impact that the implementation of all these norms have had when it comes to minorities, implementation of the treaties, etc. I've heard you speak in rather general terms that you are training judges, that you are training lawyers. But it seems to be very general, what you've said. I don't know if you've got something more tangible, something more specific on the impact that this has had, because according to our information, well, actually, it seems to be the opposite, namely that there doesn't seem to be sufficient training, awareness raising, and that perhaps the action plans, they're very broad, but perhaps don't have the necessary impact, nor do we have information on the budget that you have for implementation. You've told us that the NGOs take part on an equal footing in all these programs, but the information we've had is that NGOs are not sufficiently consulted, be it in training for human rights or other areas. We've been told that you comply with the recommendations issued by the Ombudsman. I would like to know what the level of compliance is as regards the Ombudsman's recommendations. For instance, what's the specific percentage of compliance with the recommendations of the Ombudsman? And perhaps we've preempted question 24 and issues that have to do with the right of minorities and the Orsus versus Croatia case. Perhaps we can leave this for tomorrow. Perhaps I would ask a few more questions on this particular point tomorrow, because that was the last question that I had. Thank you.
Muchas gracias a usted.
Thank you, Mr. Rodriguez Recia.
List is Ms. Shelik. Ms. Shelik, you have the floor, madam.
Muchas gracias. Ja želim da pozdravim delegaciju.
I would like to greet the delegation, and I would also like to wish you a warm welcome, as my colleagues did before me. Thank you for the constructive dialogue. And now I'm going to continue in English, because that is the official language of one of the official languages of our committee.
Continuing in English, as this is one of the official working languages of this committee. Actually, I'm very much interested in what I'm not being able to, I think, hear or read more about, and this is primary or first instance free legal aid. I'm aware that there is legislation concerning free legal aid in Croatia, and this is a great step forward, but is it in practice reachable to all? What is the situation concerning Serbian refugees or returnees to Croatia? According to our information, there are some obstacles concerning reaching and accessing free legal aid at first instance or primary free legal aid. Thank you, and tomorrow I think I'll address more issues concerning the second part of the list of issues. Thank you.
Muchas gracias.
Thank you. Mr. Politi, you have the floor.
Thank you, Mr. Chairman. I only will take 1 minute, I promise. I would like to welcome the distinguished delegation of Croatia and thank them for the presentations and for the answers provided so far. My colleague, Mr. Muhumudza, has already raised the important question of the steps taken by Croatia to regulate the transfer of small arms and light weapons. This in order to ensure that these weapons are not transferred where they may be used to commit human rights abuses. Now, my question for tomorrow, I imagine that the delegation will answer tomorrow, we would like to hear comments on this, not only in terms of substance, in other words, what steps have been taken, but also in terms of transparency of the information on this matter for the general public. Thank you.
Muchas gracias, señor.
Thank you, Mr. Politi. I don't believe there are any further requests for the floor or questions. I, however, would like to ask 2 questions of my own, if I may, added to the ones put by my question for you to answer, of course, tomorrow. The first has to do with point 3 of the list of issues, and this is basically following up from what Mr. Rodriguez Recia said. You've given us some information on the follow-up to 3 of our recommendations. These are the 3 that we establish as priority. But the question in the list of issues was to do with all the committee's recommendations, all of them. So my specific question is, do you have some specific mechanism to enable follow-up to the committee's recommendations made in their concluding observations? So, specific question, do you have a specific mechanism to do that? Because I haven't found an answer to that in paras 38 and 39 to the list of issues. Moving on to question 7, there was a question which had to do with the judging of people who'd taken part in a gay pride march. The list of apparently there was a definitive sentence pertaining to 16 complaints, but we don't know exactly what was in the ruling, the sentence. This is in 63, para 63 of your answer to the list of issues. What was the result of these sentences, these judgments? This has to do with these people who were accused of attacking, assaulting people who were participating in the Gay Pride March. And as regards 11 of the list of issues, this has to do with domestic violence. I'm rather concerned at para 1, 2, 3 of your answers. As I understand it, if somebody exceeds defense, then they may be detained together with the aggressor. Now, domestic violence is always the result of a situation of power, power being wielded by one person over another. So this seems to be giving the police the faculty, the option to arrest both. And surely this is something that is going to affect the victim of domestic violence. They may not react to the perpetrator and be rather vulnerable within their own homes. I've done my best myself to comply with time constraints. It's 6 p.m. on the dot, so I think we can probably leave the review for today. We'll resume tomorrow morning. I'm expecting answers from you. There may well be other questions, and we have other issues to address, such as prohibition of torture, prohibition of ill treatment. Of course, these are important issues, and we need ample time to address those tomorrow. So have a restful evening as far as you can, and tomorrow at 10 we will proceed with the review. Thank you.